So we have this Senate Bill 1909 in Illinois that Democrats passed despite Republicans saying that it's unconstitutional, and the measure ultimately allows for the Illinois Attorney General to use Deceptive Practices Act to go after crisis pregnancy centers that do not offer abortion. And this is obviously a pretty contentious issue, especially with Illinois having some of the most relaxed abortion laws in the country, as states surrounding us look to restrict that medical procedure to terminate a pregnancy. So Illinois is a desert essentially in the Midwest, and we've got a number of people coming into Illinois from out of state to terminate a pregnancy. So in the context of all of that, you had state legislators looking at various ways they could beef up Illinois law to, do a variety of things. For instance, you've got Illinois law that prohibits local law enforcement with certain types of license plate reading camera technology to not be able to share that data with out-of-state prosecutors that may be looking for somebody coming from out-of-state into Illinois to get an abortion. And the proponents of this saying that an individual should not be targeted for this, but opponents of that particular law said that it could lead to somebody who is bringing a minor child that they abused into Illinois to get an abortion, and therefore not able to actually track that individual adult who might be bringing that minor child in to get an abortion after being abused. So some of the contention there, you can see obviously it's a growing issue and something that you have various other types of proposals being made at the Illinois State House. But with the issue of Senate Bill 1909, this is the measure that allows the Attorney General to go after crisis pregnancy centers for not offering abortion, alleging deceptive practices. Well, in the federal courts, you've got the latest here from the National Institute of Family Life Advocates versus Kwame Raoul. And that case was filed July 27th, just days after Governor J.B. Pritzker signed Senate Bill 1909. So if you look at the dockets, you go through and you can see when it's filed and all the various backs and forth, and also the injunction that was issued on this. If you recall, the judge first chastised the state for looking to delay a response, and the judge said that plaintiffs should provide personal service. It goes on to say that the list of questions the court will raise the preliminary injunction hearing. Some questions are factual, some questions are legal, some are a mix of fact to the extent they need to answer these. The judge also went on to essentially chastise the state for putting in a meritless motion, the judge said, in a denial of the defendant's motion to delay a response, saying that this lawsuit should not come as a surprise to defendant. Any standing concerns and any judicial issues can be addressed during the hearing. So they moved forward with the hearing, and ultimately after the hearing, an issue of a preliminary injunction was granted. So the law is on hold. As of right now, Senate Bill 1909 is not enforceable. And we had questions into the Attorney General's office when they were going to appeal that preliminary injunction. Even Governor J.B. Pritzker having said several weeks ago that he was not informed on whether the Attorney General was actually going to move forward with an appeal. Well, on Friday, you had that appeal issue, not an appeal, but an answer. So still no appeal. So the issue of 1909, Senate Bill 1909 being having an injunction, a preliminary injunction issued against it, where the judge said that the law is stupid and likely unconstitutional. The preliminary injunction still in place, but you have the Attorney General's office file an answer to the complaints from the National Institute of Family and Life Advocates. So let's go ahead and take a look at the answers. If you're not familiar with what this is, it's essentially like a back and forth of here's what the plaintiffs allege, here's the answer. So here's just kind of how this rolls, right? So an answer. Defendants admit the First Amendment, as interpreted by the judiciary, generally provides the governments may not establish religion, prescribed political or moral orthodoxies, silence opposing viewpoints, or require disfavored citizens to speak. Defendant further admits that paragraph 1 accurately quotes from James v. American Federation of State, County, and Municipal Employees. Defendant denies Senate Bill 1909 1909 violates the First Amendment or violates any of plaintiff's constitutional rights and denies the remaining allegations in paragraph 1. Goes on to talk about defendants admit Governor Pritzker signed into law Senate Bill 1909. So the state says, yeah, governor signed that, which amends the Illinois Consumer Fraud and Deceptive Practices Act and in part prohibits limited service pregnancy centers from engaging in deceptive practices or omitting material facts concerning pregnancy-related services. Defendant denies the remaining allegations in the paragraph. So again, it lays out what the plaintiffs have said, but they deny part of that. Defendants admit that the Illinois Attorney General's office played a role in drafting Senate Bill 1909 and will enforce it subject to preliminary injunction currently in place. So again, that preliminary injunction is in place. Defendants deny the remaining allegations in paragraph 3, where the allegations are abortion facilities as well as expressly exempted licensed healthcare providers and hospitals remain free to engage in their own controversial speech about abortion as they wish. So the defendants saying that they deny that allegation. So it goes on for almost 60 pages answering a variety of things. Defendant lacks knowledge of information sufficient to form a belief as to the truth of the allegations of paragraph 10, where it's alleged that plaintiffs have assisted thousands of women in navigating the uncertainty of difficult, untimely pregnancies with love and compassion. So the defendants lack knowledge of that information. So again, 60 some odd pages of answers and a breakdown of the various allegations that are being made against the state of Illinois when it comes to Senate Bill 1909 with a preliminary injunction still in place. And when are we going to see this case particularly heard? Let's take a look back at the docket, where looks like at least here from several weeks ago, you've got the court essentially laying out that by October 16th, the parties shall jointly file initial status reports form found on the judge's website. The parties shall participate in a conference and exchange their disclosures by October 20th. A telephonic status conference is set for October 23rd, and the public will be able to access that by calling into a number and hitting an access code. So October 23rd really is when they're going to have a hearing on this case, so we'll be tracking that as well. All right, so it is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. Coming back, the Illinois Supreme Court's going to have a busy couple of weeks here. Starting today, they're going to be hearing a case about a allegation that a criminal defendant had a murder confession tortured out of him. That's just one case that's going to be heard today, but another case going to be heard next week deals with the Freedom of Information Act and the firearm owner's identification card. So we'll take a look at some of that coming back next here with Springfield's Morning News on 92.7 WMAY. Springfield's News and the Illinois Supreme Court's going to have a busy couple of weeks here as they have a mountain of cases they're going to be hearing starting today here in Springfield. They've got, 3 or 4 different cases, and then tomorrow, Wednesday, Thursday, they've also got cases they're set to hear, but they're also going to be hearing cases Tuesday, Wednesday, and Thursday of next week as well. One case they have in particular that they're going to hear today deals with an alleged police torture getting a confession out of somebody. And let's take a look at this particular case. It's docket number 128,373. Of course, you can find all of this on the Illinois Supreme Court's website, where you can also stream the hearings live. So you can watch all of this unfold and look at all the appellate's brief and the appellant's brief. And in particular, this case about Darrell Fair versus the people of Illinois. And it goes through some of the things about these Supreme Court cases. It talks about the nature of the case. Fair was convicted of a 1998 murder based on an accountability theory, supported exclusively by a false oral statement made after a 30-hour custodial interrogation marked by physical abuse and deprivations of medication, food, and counsel. So the Torture Inquiry and Relief Commission found a credible claim of torture and referred Mr. Fair's case to the circuit court. So at issue, they say that the case involves the undisputed denial of Mr. Fair's right to counsel, violence of threats and violence against him, so on. So you can see here some of the things they're going to be hearing about during that hearing today, touching on this case. But if you look again at all of the different cases there are for the Illinois Supreme Court over the next few days and into next week, just to kind of go through some of these. One deals with a DUI conviction with a judge substitution and pro se issues. You've got a murder conviction allegedly without following proper protocol. In a separate case, you've got a conviction on a case with questions of whether exculpatory evidence was withheld. In the case number 128871, it says here that whether the state proved beyond a reasonable doubt that Santana Grayer, a voluntarily intoxicated Lyft passenger trying to get home safely from a social gathering, had the specific attempt to hijack his Lyft driver's car, where evidence of Grayer's voluntary intoxication was introduced at trial but not raised as an affirmative defense. So that'll be interesting to watch that unfold. And again, that'll be later on this week, Thursday, when case number 128871 will be heard. And then next week, you've got a case Tuesday that's going to be heard concerning the Freedom of Information Act and also the FOID card. So this is an interesting case. It's case number 128275. And when you look at this, some of the issues at hand, we'll just scan through the brief. Nature of the case: Sandra Hart and Kenneth Burgess each submitted a request to the Illinois State Police under the Illinois Freedom of Information Act seeking production of their applications for firearm owners' identification cards and their denial on revocation letters from ISP. ISP denied the request, citing FOIA law, which prohibits releasing the names and information of individuals who have applied for FOID cards. For Burgess's request, ISP also argued that it was bound by a permanent injunction entered by a circuit court in another case prohibiting the release of FOID card information. Hart and Burgess each filed FOIA actions in the circuit courts, and their subsequent motions for summary judgment were granted on the ground that, in the circuit court's view, the section of the law contains an unwritten exemption to its blanket prohibition on disclosures. ISP, State Police, appealed both judgments. So this is going to be an interesting case next week. And what's fascinating here is this case is being handled for the plaintiffs by Thomas Magg. So we've talked to Thomas Magg several times, so we'll have to connect with him to get why this case is so important for these two individuals looking to get information about their FOID card applications using the Freedom of Information Act. And my own personal experience here with FOIA, just share the story briefly. Back in, what was it, 2006 or 2007, here in Springfield, there was an arrest made. Federal prosecutors alleged that Talib Islam, formerly known as Michael Fenton, he was driving a van up to a federal building, got out thinking there was a bomb in there. He called a cell phone twice to detonate it, and then feds came in and arrested him. It was a setup. So Michael Fenton in jail, he actually, wrote me a handwritten letter. I was on the air at the time, and he wanted a jailhouse interview, and I talked with him, and he discussed how he felt that he was being set up. He had done a previous stint in prison for, I think, burglary or something, if my memory is correct. So he wanted to share his side of the story. He felt that police were, essentially entrapping him, and he just got to the point where he's fed up, and he went along with what he says and claims he knew was a setup the whole time. So right now, he was convicted of that. I think he's serving time down in Texas. But when he was in prison in Texas, he wrote me again and requested that I get his FBI file. So in order to do that, I had to get a FOIA into the FBI. The FBI responded saying we can only release this if Michael Fenton, also known as Talib Islam, grants access to that request. So I had to get Michael Fenton, Talib Islam, to essentially fill out a form saying he grants permission to have this information released. Sent that back to the FBI with the FOIA request, got the information back that confirmed that Talib Islam, Michael Fenton, was being seen as an informant of sorts. So just, again, and the reason I share that story is because Michael Fenton, as the subject of the information pertaining to a FOIA request had to explicitly grant permission for that information to be released to a third party. Is that the same type of instance here? You've got two individuals looking to get information about their own personal firearm owner identification request, and that's being denied. It's their own personal information. So I think that's going to be a crucial case to watch. Of course, I don't think anybody wants the entirety of all the firearm owner identification card information released because, well, let's face it, that could give names of gun owners and possible addresses of gun owners. And then you've got the question of, are these individuals going to be targeted by criminals? So again, that's an interesting case to watch next week. Some of the other cases that the Illinois Supreme Court's going to take up deal with a parking ticket dispute, and that's in front of the Illinois Supreme Court. Up in Chicago, a separate case has a cyclist suing the city of Chicago after they got injured hitting a pothole. But apparently the city of Chicago says the street was not designated for bicycles. Some of the other ones, you got a property tax case involving a power plant, prescription drug inquiry claims. Another interesting one next week is going to be about a youth hockey team being alleged to violate human rights by not allowing an individual to play. And questions of places of public accommodation and whether private groups using such places are required to follow such human rights standards. And then you've got medical malpractice case that's going to be heard next week, case about HIPAA, and more. So the Illinois Supreme Court's going to be pretty busy leading up into today with hearings and even next week with hearings all throughout Tuesday, Wednesday, Thursday this week, Tuesday, Wednesday, Thursday next week. So hopefully you're a little bit more informed on how the judiciary's handling all kinds